Good morning. Happy Friday. Thank God it's Friday, right? Been a hectic week for me. Um, I like to talk about things when it makes sense, like on a grander scale than just this happened. And one of those things that I get to talk about today is in Chile's case against LVMPD. The defense retained another attorney, an additional attorney. So they had two guys working on the case, and now they have three. And you're going to say, well, gee, John, why did they hire a third? Well, the guy that they hired is a former chief district attorney, I believe, for Las Vegas. And what that means is that he almost certainly has a lot of trial experience. Trial's different than your normal everyday practice of law because you've got to know the rules of evidence, like right out of the gate. Somebody asks a question, you have to get your objection out before the answer is given. It's a very intense kind of situation for an attorney. Whenever I go into a trial, like by the end of the trial, even if it's only a one-day trial, I am exhausted because your brain is just on while you're sitting there. And you'll see a lot of attorneys who don't do a lot of trials. When they get into a trial situation, you'll just see them, like at the beginning of the trial they'll be all intense, and then by the end of the trial, like they're letting tons of objectionable questions in. It's and in addition, while you're listening to the question for the objection, you're also taking notes on what you're going to cross the witness on or redirect the witness on or whatever. So I mean, it's like you're just on the ball. It is a very tough thing to do. Pro pers are going to be like, oh, I've done a bunch of trials where I represented myself, and you're like, yeah, buddy, yeah. Pro pers often in trials get a lot of leeway from the judge, where if the pro per just says objection, the judge will fill in what the objection is. I've seen that happen a lot. Attorneys don't get that. I've never seen an attorney get that anyway. If an attorney just says objection, the judge will say, okay, what's your objection, counsel? And then you've got to know what the proper objection is. Or if the other attorney makes an objection, the judge looks at you to say, hey, what's your response? And then you have to know how to respond and get past the objection. It's a different, in theory, pro pers are treated the same as attorneys at trial, but in practice, at least in my experience, pro pers are given a lot more leeway. So unless you've been an attorney, unless you've been in a trial, it's really hard to understand how difficult and mentally intensive it is to be in a trial. And most attorneys aren't in trial often, if at all. That's also just the standard thing. Most cases settle. Most criminal cases settle. Most civil cases settle. Most family law cases settle. Generally speaking, most cases don't go to trial, so it's really hard to get a lot of trial experience. Now, as a prosecuting attorney, you're probably going to get more cases going to trial than just about anybody else. In my experience, the assistant DA or whoever is prosecuting a criminal case, and remember, I have limited criminal experience, so just bear this in mind. So when I say in my experience, just bear in mind it is a limited experience. But in my experience, when it's going to go to trial, it gets bumped up to a higher person. You might get, in my experience, a lot of the DAs that you deal with at the cattle calls who are on the case, they're usually, they've been practicing law for 1, 2, 3, maybe 4 years. They usually have a DA or assistant DA above them in the chain of command that they run things through, but they kind of get to handle the case a little bit. But if the matter is going to go to trial, then the person above them who has the trial experience actually does the trial, and the younger, fresher DA, participates by sitting there and basically observing to give them experience without jeopardizing a case. So, but in my experience, like if you've if you've been a DA for a long time, you're going to have a lot of trial experience. A lot, and because the upper DAs tend to not deal with the minutia cases that are going to settle, they have a lot of trials that they're going to. So this guy that they're bringing in, it's my best get, they're bringing him in solely for the purpose of trial, to prepare for trial and to conduct the trial. Now, for everybody who gave Randall S. Newman shit because he didn't have much, if any, trial experience, it's because, generally speaking, if you're going to trial, it's important enough. Like, two kinds of cases go to trial. Cases where the plaintiff or prosecution has no case. Well, not prosecution. If the prosecution has no case, it gets usually resolved. But if the plaintiff has no case but doesn't realize they have no case, that goes to trial. And big money cases go to trial. $1 million+ cases, those are more likely to go to trial than someone suing for 20 grand, right? So if you end up going to trial, that means there's usually a lot at stake. And that's when you want to have an experienced trial attorney in there doing the trial. It's very common. I've had multiple cases against large law firms where when it looked like it was going to trial, they brought in another attorney who does trials. Their caption will literally say trial attorney. I've been brought in to conduct trials for other attorneys because they don't have enough experience and they wanted someone with experience doing trials to conduct the case. Now, I don't have as much experience as someone who's been practicing law as a chief DA for, 15 years. I'm only a first-year family law attorney, but I've conducted a fair number of trials. So what I'm trying to say is, number one, it's really bad for DeCasto that they're bringing in an actual trial attorney. I seriously doubt his attorney, Michael Mee, has a lot of trial experience. Does that mean he's going to lose? No. Does that mean that the LVMPD is going to win? No. But it does shift the odds in LVMPD's favor to have an experienced trial attorney in there, especially against what I am going to assume is a much less experienced trial attorney in Michael Mee. And the other thing is that it doesn't reflect poorly on Randy that Randy hasn't done many, if any, trials. Because what Randy does is, in Randy's experience as an attorney, he probably gets most of his cases settled, because that's how most cases happen. They get settled. And only on the few cases where he couldn't get them settled, they went to trial. So, pick on Randy for all the dumb shit that he does, yes, but him not having trial experience doesn't negatively reflect on him as an attorney. He's just not a trial attorney. Michael Mee probably hasn't done many trials. I understand he's a criminal defense attorney, but most of those cases settle. And if Michael Mee had his way, he would have settled DeCastro's case. And if I remember correctly, looking at Michael Mee's, I guess like his law firm's page, he talks about getting favorable settlements. He probably doesn't have a lot of experience as a trial attorney, just saying. So it's an interesting situation. I don't know if we'll actually get to see the trial, but it would be interesting to watch the trial. I would watch the trial to see how Michael Mee performs against a very experienced former chief district attorney. But yeah, we'll see. Thanks for watching. I hope you guys have a wonderful weekend.